The year is 2025, a time of significant political and social change in India. The Indian Parliament is embroiled in a heated debate over the Waqf Amendment Bill 2025. This bill has sparked intense discussions among lawmakers, activists, and the general public. This bill aims to amend the Waqf Act of 1995, particularly by removing Section 40. The original act was designed to regulate and protect Waqf properties, which are charitable endowments under Islamic law. Section 40 grants the Waqf Board crucial powers in managing Waqf properties. These properties include mosques, schools, and other community assets that serve the Muslim population. The ruling coalition champions the bill for transparency and efficiency, arguing that it will streamline the management of Waqf properties. However, the opposition decries it as an assault on the Waqf Board's autonomy, fearing it could lead to government overreach. The debate touches on religious freedom, minority rights, and the balance between state power and institutional autonomy. Many see this as a pivotal moment for the protection of minority rights in India. The outcome holds significant implications for the Waqf Board, the Muslim community, and India's secular ethos. The decision will likely influence how religious and community properties are managed in the future. The Waqf Amendment Bill 2025 is about shaping the future of Waqf in India. Its passage or rejection will set a precedent for how the country navigates the complex interplay between religion, law, and governance. In Indian society, the Waqf Board is the custodian of Waqf properties. These properties are not just pieces of land or buildings, they are symbols of a rich cultural and religious heritage that has been passed down through generations. Waqf, an Islamic practice of endowing property for religious or charitable purposes, represents a tradition of philanthropy. This practice has been a cornerstone of Islamic society, ensuring that wealth is distributed to benefit the community, especially the underprivileged. The Waqf Board, established under the Waqf Act of 1995, ensures proper management and utilization of these endowments. The act was a significant step towards formalizing the administration of Waqf properties, aiming to protect them from misuse and ensure they serve their intended purpose. Waqf properties include mosques, dargahs, orphanages, and educational institutions. These institutions play a crucial role in the social and educational upliftment of the community, providing essential services and support. Serving as vital pillars of the Muslim community, they offer a sense of belonging and continuity, connecting the present generation with their cultural and religious roots. The board's role extends beyond property management to preserving cultural and religious heritage. This includes maintaining historical buildings, supporting religious ceremonies, and organizing cultural events that keep traditions alive. Allegations of corruption and mismanagement have plagued the institution, raising questions about its efficacy. These issues have led to public outcry and demands for greater transparency and accountability in the board's operations. The Waqf Amendment Bill 2025 aims to reform Waqf management, addressing these concerns while ensuring the board's role as a protector of Waqf properties. The proposed amendments seek to enhance oversight, improve governance, and restore public trust in the institution. Section 40 of the Waqf Act of 1995 is the backbone of Waqf property determination. It empowers the Waqf Board to investigate and determine the status of properties suspected to be Waqf. This section serves as a safeguard against encroachment or misappropriation of Waqf properties. Section 40 grants the board a unique legal standing, enabling it to act as a quasi-judicial body. Its potential removal under the Waqf Amendment Bill 2025 has sparked widespread concern. The future of Waqf property determination and the board's ability to fulfill its mandate are at stake. Deconstructing Section 40. A closer look at its provisions. Section 40 of the Waqf Act, 1995, is divided into distinct parts, each addressing a specific aspect of Waqf property determination. This section is pivotal in ensuring that properties dedicated for religious or charitable purposes are correctly identified and managed. The first part empowers the Waqf Board to initiate investigations into properties suspected of being Waqf. This means that if there is any doubt or suspicion about a property being Waqf, the board has the authority to look into it thoroughly. The second part makes the board's decisions on Waqf property status final and binding, subject only to appeal in a Waqf tribunal. This ensures that there is a clear and authoritative process for resolving disputes. The third part allows the board to investigate properties registered under other trusts or societies. This provision is crucial because it prevents the misclassification of properties and ensures that all Waqf properties are properly accounted for. The fourth part reinforces the Waqf Tribunal's role as the final arbiter in disputes related to Waqf property. This tribunal acts as a specialized body with the expertise to handle such sensitive matters. Understanding these components is crucial to grasping the full scope of Section 40. Each part plays a significant role in the overall framework of Waqf property management and dispute resolution. The implications of its potential removal are significant. Without these provisions, there could be a lack of clarity and increased disputes over Waqf properties, affecting the communities that rely on them. The rationale for removal: government's push for transparency and efficiency. The government justifies the removal of Section 40 by citing the need for greater transparency, accountability, and efficiency in Waqf property management. They argue that Section 40 creates delays and bureaucratic hurdles, hindering effective utilization of Waqf assets. The concentration of power in the Waqf board has, in some cases, led to corruption and mismanagement. The proposed removal aims to streamline Waqf property management by transferring some powers to other government bodies. The government's vision includes digitizing Waqf records and creating a centralized online portal for transparency. Implications of removal: a balancing act between autonomy and accountability. The potential removal of Section 40 has ignited a fierce debate. Critics argue that it could weaken the Waqf board's authority and limit its ability to manage Waqf properties effectively. They fear increased government control and political interference in Waqf affairs. Proponents argue that the changes will create a more transparent and accountable system. The debate centers on balancing the Waqf board's autonomy with the need for oversight. The outcome will have significant implications for Waqf management and the Muslim community. Political crossfire: a spectrum of views on the amendment. The Waqf Amendment. Bill 2025 has become a political hot potato. The ruling BJP defends the bill as a step towards reforming Waqf management and curbing corruption. The opposition, including Congress, opposes the bill, calling it an assault on the Waqf board's autonomy. They accuse the BJP of using the amendment to further its Hindutva agenda. Regional parties have taken nuanced positions based on local political calculations. Civil society organizations and activists have voiced their opinions, both for and against the proposed changes. Muslim organizations express concerns about the potential impact on religious freedom and Waqf properties.